Harris.
Thank
Senator
you.
Harris.
Judge, as you know, these hearings are a place to hopefully get answers, and as I'm sure you've noticed, your lack of a clear answer to a question I asked you last night has generated a lot of interest. I received reliable information that you had a conversation about the special counsel or his investigation with the law firm that has represented President Trump. As you'll recall, last night I asked you whether you'd had such a conversation, and under oath, you gave no clear answer. Then today, my Republican colleagues raised the issue with you, and again you said you don't recall and that you had no, quote, inappropriate conversations with anyone at that law firm, which has led a lot of people to believe that that was equivocal in terms of a response. So whether a conversation was appropriate, in your opinion, is not a clear answer to my question. My colleague, Senator Blumenthal, again asked you, and you said you were, quote, pretty confident. The answer was no. So frankly, if last night you had just said no, or an absolute no even today, I think this could be put to rest. But I will ask you again, and for the last time, yes or no, have you ever been part of a conversation with lawyers at the firm of Kasowitz, Benson, Torres about special counsel Mueller or his investigation? And I asked, were you ever part of a conversation? I'm not asking you what did you say.
Right.
I'm asking you, were you a party to a conversation that occurred regarding special counsel Mueller's investigation? And a simple yes or no would suffice.
About his investigation. And are you referring to a specific person?
I'm referring to a specific subject, and the specific person I'm referring to is you.
Now, who was the conversation with? You said you had information.
That is not the subject of the question, sir. The
Okay.
subject of the question is you and whether you were part of a conversation regarding special counsel Mueller's investigation.
The answer is no.
Thank you. And it would have been great if you could have said that last night.
Well,
Thank you.
Never mind.
Let's move on.
Okay.
Yesterday, Senator Blumenthal asked if you could recuse yourself in cases involving the personal civil or criminal liability of the president. You declined to say that you would. So my question is, could a reasonable person question your independence in cases involving the president's civil or criminal liability?
I'm sorry, can you repeat it one more time?
Would it be reasonable for someone to question your independence in cases involving the president's civil or criminal liability should that occur?
My independence, I believe, has been demonstrated through my 12-year record, and what you've heard from the people who've worked with me. And I believe deeply in the independence of the judiciary. I rule based on the law, and you can look at cases that I've ruled against when I became a judge, against the Bush administration, and I've talked about the history of our country and the history of the Supreme Court.
And on that point, sir, in particular the history of the Supreme Court and confirmation hearings, Justice Kagan, during her confirmation hearing, committed to recusing in cases she handled as Solicitor General. Justice Breyer committed to recusing in cases implicating his financial interest in Lloyd's of London. Justice Ginsburg refused to commit to recusing in cases that were on her D.C. Circuit recusal list. Justice Scalia committed at the hearing to recuse in a case implicating an issue that was the same as an issue he had decided as a D.C. Circuit judge. So my question to you is, will you commit to recusing in any case involving the civil or criminal liability of the president who appointed you?
Right.
Or nominated you?
The independence of the judiciary requires that I not commit to how I would decide a particular case and to issue a commitment on a discretionary recusal issue in either direction. So if I answered that question in either direction, that would be I would be violating my judicial independence, in my view, by committing in this context. I've explained.
So, but with all due respect, sir, if I've shared with you that other nominees sitting at that desk or some desk like that have committed to recusing. There have been circumstances where they have committed. So is it your opinion then that they violated some ethical code or rule?
I don't know all the circumstances, but I believe those were situations that were required recusals where they had previously had to recuse and were simply indicating their required recusals but I don't know all the circumstances. A discretionary recusal is a commitment to get a job, or discretionary non-recusal as a commitment to get a job. Either direction would be violating my independence as a judge, as a sitting judge, and as a nominee to the court.
Okay, it is clear you're unwilling at this point to commit to a recusal, so we can move on. One of your mentors, Justice Kennedy, wrote landmark opinions in the area of LGBTQ rights that have had a major impact on the lives of many Americans. Let's discuss one of those cases, and that's the Obergefell case. In Obergefell, as you know, the court held that same-sex couples have a right to marry. My question is whether the Obergefell case was correctly decided, in your opinion.
Senator, Justice Kennedy wrote the majority opinion in a series of 5 cases, Romer versus Evans.
If we can just talk about Obergefell, that'd be great.
But I want to explain it.
I actually know the history leading up to Obergefell. So can you just please address your comments to Obergefell?
So I would like to explain it if I can. He wrote the majority opinion in Romer versus Evans, Lawrence versus Texas, United States versus Windsor, Obergefell, and Masterpiece Cake Shop. Concluding in Masterpiece Cake Shop, importantly, with a statement, if I could just read this.
But no, please don't, because I actually have read it, and I'm sure most have. My question is very specific. Can you comment on your personal opinion on whether Obergefell was correctly decided? It's a yes or no, please.
In Masterpiece Cake Shop, and this is, I think, relevant to your question, Justice Kennedy wrote, in the majority opinion, joined by Chief Justice Roberts and Justice Alito and Justice Gorsuch and Justice Breyer and Justice Kagan, the days of discriminating against gay and lesbian Americans or treating gay and lesbian Americans as inferior in dignity and worth are over. Paraphrasing.
Right. Do you agree with that statement?
That is the precedent the Supreme Court agreed with by
Sir, I'm asking your opinion. You're the nominee right now, and so it is probative of your ability to serve on the highest court in our land. So I'm asking you a very specific question. Either you're willing to answer or not, and if you're not willing to answer it, we can move on. But do you believe Obergefell was correctly decided?
So each of the justices have declined, as a matter of judicial independence, each of them to answer questions in that line of cases.
So you will not answer that question?
Following the precedent set by those 8 justices, they've all declined.
Thank you.
When asked to answer that question.
I have limited time, so
but it's important
I'd really like to move on.
Yes.
You've said that Brown v. Board of Education was one of the greatest moments in the court's history. Do you believe that Obergefell was also one of those moments?
I've said, Senator, consistent with what the nominees have done, that the vast swath of modern case law, as Justice Kagan put it, you can't, as a nominee in this seat, give a thumbs up or thumbs down. That's her words.
Do you think that Obergefell was one of the great moments in the history of the Supreme Court of the United States?
And for that reason, those nominees have declined to comment on recent cases.
Is it a great moment is what I'm asking you, not to comment on the legal analysis. Do you believe that was a great moment in the history of the court?
So the Justice Kennedy wrote the majority opinion saying the days of treating gay and lesbian Americans or gay and lesbian couples as second-class citizens or inferior in dignity and worth are over in the Supreme Court. That's a very important statement, Senator.
I agree. That's why I think you repeated it. Thank you. Let's move on. Over the last several months, we have all witnessed the inhumane and heartbreaking separation of immigrant children from their families by this administration. Despite a court order requiring the administration to reunite them over a month ago, nearly 500 immigrant children are still separated from their parents. Do you believe that constitutional rights of parents, specifically fundamental due process rights, are implicated in such family separations?
Senator, that is a matter of pending litigation, I believe, and as a sitting judge on the D.C. Circuit or as a nominee, I, of course, can't comment.
Have you watched the coverage of any of these cases on television, or have you read about the experiences those parents and those children have had?
I have seen some television.
In the 1889 Chinese exclusion case, the Supreme Court permitted a ban on Chinese people entering the United States. The court said Chinese people are, quote, impossible to assimilate with our people, end quote, and said they were immigrating in numbers, quote, approaching an invasion. This case has never been explicitly overruled. You've said you'd be willing to talk about older cases. So can you tell me, was the United States Supreme Court correct in holding that Chinese people could be banned from entering our country?
Senator, the cases in the 1890s, as you know,
1889 to be specific.
okay, in that era, reflect discriminatory attitudes by the Supreme Court. Of course, that's the era also of Plessy versus Ferguson.
So would you be willing to say that that was incorrectly decided?
Senator, I don't want to opine on a case, a particular case, without looking at it and studying it. But the discrimination.
Are you aware that that case has not been overturned?
Senator, I know that with a number of the cases, like Korematsu, let me use that as an example.
Which we've discussed earlier. But
That
on
is-
this case in particular, were you aware that it had not been overturned?
So, Senator, I realize that there's still cases in the immigration context.
Have you ever written about any of those cases and your thoughts about whether they should be re-examined or potentially overturned? And sometimes, obviously, they should be overturned?
Well, there is a swath of cases.
Have you talked about this case ever?
I do not believe. I'm happy to be refreshed if you have something that suggests I have.
No, it's actually a question.
Okay.
Under the Constitution, Judge, do you believe that Congress or the President can ban entry into the United States on the basis of race?
Senator, that was of course, one of the issues that was just in litigation, and there's still litigation about the immigration laws and how
you're not gonna answer
exclusions. That's pending litigation, so I think as a matter of independence and precedent.
Will not answer that. That's fine. Let's move on. In 2013, Texas passed a law that imposed new restrictions on health care facilities that provide abortions. The effect was that after the law was passed, half those facilities closed, which severely limited access to health care for the women of Texas. In 2016, Whole Women's Health was decided, wherein the Supreme Court invalidated the Texas restrictions. Was Whole Women's Health correctly decided, yes or no? And we can keep it short and move on.
Senator, consistent with the approach of nominees.
You will not be answering that.
Following that nominee precedent.
Okay, I'd like to ask you another question, which I believe you can answer. You've said repeatedly that Roe versus Wade is an important precedent. I'd like to understand what that really means for the lives of women. We've had a lot of conversations about how the discussion we're having in this room will impact real people out there. And so my question is, what in your opinion is still unresolved? For example, can a state prevent a woman from using the most common or widely accepted medical procedure to terminate her pregnancy? Do you believe that that is still an unresolved issue? I'm not asking how you would decide it.
Sir, I don't want to comment on hypothetical cases. Roe v. Wade is an important precedent. It's been reaffirmed many times.
So are you willing to say that it would be unconstitutional for a state to place such a restriction on women for Roe v. Wade?
You can, the precedent of the Supreme Court in Roe was reaffirmed in Planned Parenthood versus Casey, of course, and that's precedent on precedent. And then there are a lot of cases applying the undue burden standard, and those themselves are important precedents, and I had to apply them.
And we've discussed that many times. I've actually had the benefit of sitting through most of the hours of your testimony over the last 2 days, so I know you've talked a lot about that. Can Congress ban abortions nationwide after 20 weeks of pregnancy?
Senator, that would require me to comment on potential legislation that I understand, and therefore I shouldn't, as a matter of judicial independence, following the precedent of other nominees,
then
do
we
that.
can move on. I'm going to ask you about unenumerated rights. So you gave a speech praising former Justice Rehnquist's dissent in Roe. There's been much discussion about that, and you wrote, quote, celebrating his success, that success in stemming the general tide of freewheeling judicial creation of unenumerated rights. That is what you said in celebration of Justice Rehnquist. So unenumerated rights is a phrase that lawyers use, but I want to make clear what we're talking about. It means rights that are protected by the Constitution, even if they're not specifically mentioned in the Constitution. Right. So they're not in that book that you carry. So what we're talking about is the right to vote. That's an unenumerated right. The right to have children. The right to control the upbringing of your children. The right to refuse medical care. The right to love the partner of your choice. The right to marry. And the right to have an abortion. Now, putting those unenumerated rights in the context of the statement you made, which was to praise the stemming of the general tide of freewheeling creation of unenumerated rights, which means the interpretation there is you were praising the quest to end those unenumerated rights. My question to you is, which of the rights that I just mentioned do you want to put an end to or roll back?
3 points, I believe, Senator. First, the Constitution. It is in the book that I carry. The Constitution protects unenumerated rights. That's what the Supreme Court has said.
But that does not explicitly protect the rights that I just listed, and we both know that that's the case.
Right, so that's point one. Point two is Glucksberg, the case you're referring to. Specifically cited Planned Parenthood versus Casey as authority in that case. So Casey reaffirmed Roe. Casey is cited as authority in Glucksberg. That's point two. And point three, Justice Kagan, when she sat in this chair, pointed repeatedly to Glucksberg as the test for recognizing unenumerated rights going forward. In describing the precedent, I agree with her description of that in her hearing.
So thank you for that. So then let's put the rights that I mentioned, which are unenumerated, in the context of your praise of Justice Rehnquist as having stemmed the general tide of freewheeling judicial creation of unenumerated rights. Arguably, every right that I mentioned on that list was a judicially created, unenumerated right. And my question then is, when you praise a jurist who attempted to end those rights, which rights in particular do you believe are praiseworthy of ending?
Right. So that was the test that was set forth by the Supreme Court going forward for recognition of additional unenumerated rights. That was cited as authority in that case, Planned Parenthood versus Casey, which reaffirmed Roe.
So let's talk about the right to vote. Do you believe that that falls in the category of having been caught up in the general tide of freewheeling judicial creation of unenumerated rights?
What I was describing with Chief Justice Rehnquist, and it was a description of his career. It was in a variety of areas, and his role.
Specifically, your reference was to unenumerated rights,
right.
sir.
And in a number of areas. I described 5 different areas of his jurisprudence where he'd helped the Supreme Court achieve what I think has been a common sense middle ground that has stood the test of time in terms of precedent in a variety of areas. At least that's how others have described it. The Glucksberg case, as Justice Kagan explained when she was in this chair, is the case that the Supreme Court has relied on for forward-looking future recognition of unenumerated rights.
Thank you, sir. I'm familiar with that. I think you're not going to address the specific enumerated rights, or are you? Because if not, we can move on.
I think I've addressed it. Thank you, Senator.
Okay. In 2011, you were a judge on one of the challenges to the Affordable Care Act. The court you sat upon held there that you dissented on procedural grounds on the court which upheld the act. One of your former law clerks described your opinion in that case, and that's the Seven Sky case, as, quote, a thorough takedown of the individual mandate. He would go on to clerk for Supreme Court Justice Kennedy that year or the next year, and the Supreme Court then held or heard the challenge to the Affordable Care Act, and according to him, your opinion was, quote, a roadmap for the dissenting justices, the ones who would have struck down the Affordable Care Act. Given you wrote the, quote, roadmap, according to your law clerk, could one reasonably conclude that you would have voted to strike down the Affordable Care Act had you been on the Supreme Court?
Couple points, Senator. First, I concluded in one case I upheld the Affordable Care Act against an origination clause challenge. In the case you're referring to, I did not reach the merits, but I discussed the merits that were being argued in both directions. My opinion's been described as the roadmap for both sides because I described both positions. And actually, it wasn't a roadmap at all because I
He
didn't
also
reach.
described it as a takedown.
Well, I speak for myself, and my own opinions speak for themselves. And
It
what
was
my
out of line then, and I'm sure the chairman wants to close this questioning, so we can leave it with that. I thank you,
right.
Judge.